Hello, I'm Gretchen Sable, and I'm Program Chair for the League of Women Voters of the Anoka, Blaine, Coon Rapids area. This program is coming to you from Andover, Minnesota. We thank the City of Andover for allowing us to use the City Council chambers for this filming. First, I'm going to share some information about the League of Women Voters. The League of Women Voters ABC is a grassroots, nonpartisan organization that encourages informed and active participation in government and influences public policy through education and advocacy. We do not support or oppose any candidate or political party. Our league, the LWB-ABC, meets on the second Monday of the month in Andover's City Hall's Senior Center, which is located at 1685 Crosstown Boulevard Northwest in the same building as City Hall. All men and women are invited to attend and participate. Even though we're called League of Women Voters, we are open to everyone. The League of Women Voters studies issues and takes positions on topics that are critical to the open, transparent function of our government. Campaign finance is one such topic. In an LWV study, a committee is formed to study facts and gather information, eventually developing a draft position. Input from local leagues is then sought. If there's consensus about the draft position, it's adopted as an official position of the League of Women Voters. So now recently, the League of Women Voters US, so this is the National League, voted to update the League's position on campaign finance reform in light of recent Supreme Court decisions that really changed the way the campaign finance system works in the US. This League update will seek League members' understanding and agreement as to the extent to which our organization believes that financing a political campaign is speech protected by the First Amendment. Leagues are being asked to consider the rights of individuals and organizations to express their political views through the financing of political campaign activities as they discuss this issue. The First Amendment has been at the center of campaign finance debate since the 1970s. A key provision of the First Amendment says, Congress shall make no law abridging the freedom of speech or of the press. So now the issue of money in politics has a long history in the U.S. In 1907, the Tillman Act banned contributions from national banks and corporations in response to corruption during the Gilded Age long ago. The 1947 Taft-Hartley Act extended the ban to labor unions. The 1971 Federal Election Campaign Act and its 1974 amendments put further restrictions on campaign contributions and spending. They also expanded disclosure and created the Federal Election Commission to oversee compliance. The 2002 Bipartisan Campaign Reform Act, also called McCain-Feingold Act, tried to remedy the explosion of soft money that we saw in the 80s and 90s. The activities that the court focused on largely involved free speech. To the court, campaign speech, as opposed to campaign finance, is central to American democracy and is what the First Amendment was designed to protect. Whatever else it may or may not have done, the Supreme Court's decision in the 2010 Citizens United versus Federal Election Commission and other cases galvanized the campaign finance reform movement. Any education and discussion of these issues must attempt to be comprehensive, which means complex. The task of League of Women Voters' current study is to make the issues understandable to members of the League and to all citizens. So in tonight's meeting, we're going to focus on the issue of campaign finance. We're pleased to welcome Mr. Gary Goldsmith, Executive Director of the Minnesota Campaign Finance and Public Disclosure Board. This board, a state agency, oversees campaign spending, registered lobbyists, and provides information to the public on candidates' economic disclosures. With Mr. Goldsmith tonight, we have Representative Jerry Newton and former Representative Kathy Tingelstad. So the way our program is going to work, Mr. Goldsmith is going to give us a presentation of about 45 minutes. We're going to take a short break, and then we'll have a discussion period with Representative Newton and Tingelstad all up front here, and we'll be able to take questions from the audience. A short intro on Mr. Goldsmith. Gary's a graduate of the University of Minnesota Law School. He spent 11 years in private practice before he joined the staff of the Minnesota Historical Society. Here, he managed their contracting and purchasing options. Later, he joined the Minnesota Campaign Finance and Public Disclosure Board as Assistant Executive Director, where he served for 5 years. He spent some time away from the board and then returned in 2006 and was appointed as the board's Executive Director in December 2007. Gary is the public face of the board and represents the board in its work with the legislature and the governor's office. And with that, I give you Gary Goldsmith.
Thank you. Everybody can hear me? For you here and for people listening to this at home, I want you to take a look at the name of the organization up on the slide, the Minnesota Campaign Finance and Public Disclosure Board. This is a state agency, and actually it's your state agency. We serve the citizens of Minnesota in the area of campaign finance regulation and disclosure. So first of all, I want to tell you a little bit about this board. This is a board of 6 people. They're all citizens just like you. Some of them have been legislators in the past. Some of them are lawyers. Some are women. Some are men. They're appointed by the governor, and it's the only board in Minnesota that has to be confirmed by both the House and the Senate. Every other board or agency, their leaders and their members get appointed by the Senate only. But because the Campaign Finance Board has so much to do with elections, and elections have a lot to do with House members and senators and others, the House wanted approval of board members as well. And not only do we get approved by both bodies, but we have to be approved by a supermajority. And when I say we, I don't mean myself, I mean the board members, but because I speak for the board and I work for the board, I often refer to the board, the membership, the staff, and myself as a we. And again, as I said, we're here to serve the public by providing you with information about campaign finance that you wouldn't otherwise get. The board can never have more than 3 members of the same political party, and right now it has 3 Republicans and 3 Democrats. And it meets about once a month. It acts sort of like a board of directors to the staff, which acts as the operations of the board. So the board sets policy, it makes important decisions, it hires the executive director and can fire the executive director if it should so choose. But the executive director runs the everyday operations of the board. So I hire the rest of the staff, I keep the business operating, and we handle all of the interactions with citizens, with legislators, and so on. The board has been in existence for about 42 years, and I'm the 5th executive director of the board. So unlike other state agencies, the board has long-term executive directors, and that's partly because of the fact that the executive director is not appointed by the governor, but rather by the board itself, and so there's a continuity. We don't have a change in staff every time we have a change in governor. And so with that introduction, I want to start talking about campaign finance issues in 2016, but in order to do that, I want to elaborate on the history that you just heard about campaign finance, because we're sort of in a quagmire here where we seem paralyzed and unable to do anything in the area of disclosure or regulation, which some people find important. On the other hand, other groups think that we're stepping on too many toes by requiring disclosure, and they're more in favor of privacy and so-called freedom of speech. So I want to go back and help us trace the roots of these principles so we know how we got to where we are, and that will help you understand why it's so hard to do anything about these so-called problems. So we're really back about 225 years, 1791. That's when the Constitution of the United States was ratified. And if you remember, the Constitution didn't really have universal support. People who supported states' rights were really concerned about this powerful federal government. So at the same time the Constitution was ratified, so was the Bill of Rights, and that's the first 10 amendments. So when we talk about the first 10 amendments, we're talking about the First Amendment in the Bill of Rights, and that is the amendment that, as your previous speaker said, says Congress shall enact no law abridging the freedom of speech. Now there were other things, religion and so on, but speech is the one we're talking about tonight. That applied to Congress. What about the states? That's where a lot of the election activity takes place. Well, we have to wait a long time till 1868 before there's anything that protects you and your speech from laws the state might enact. And if you know your history, the Civil War ended in 1865. 1868 was what we call the period of Reconstruction. That was when the Union was starting to try to reconstruct itself back into a union. And while equal rights were pretty well accepted, to some extent, not compared to maybe today, but in the northern states, the southern states really didn't want any part of it. They were not willing to say that everybody has a right to due process or to freedom of speech or any of the other things that are in the Bill of Rights. And so Congress passed the 14th Amendment, which extends the Bill of Rights to the states. So now everything that's in those first 10 amendments also applies against the states. So we move forward, and of course elections are going on. We move forward to 1904. Teddy Roosevelt was president, and there were claims that Teddy Roosevelt got elected because the corporations spent their money to get him elected. It's the first scandal that I'm going to talk about tonight, and that's kind of an important word because you'll realize as we talk that every time there's a scandal, the law gets changed, and otherwise it just sort of cruises along. So Teddy Roosevelt is accused of getting elected based on corporate money, and he thinks he's going to do something about it, and so he advocates for the prohibition of the use of corporate money in political campaigns, and that's the Tillman Act that was mentioned before. And so this is back in the early 1900s. Corporations can't participate in campaigns. You'll realize when we get up to 2010 and Citizens United, when people were complaining so loudly about the Supreme Court reversing 100 years of history, this is part of that history. So now after the corporations can't make contributions, people start thinking about disclosure. Where is this money coming from? How is it getting spent, and so on. And so between 1910 and 1911, the first disclosure acts were introduced in Congress. And there were further developments in the next 50 years or so. There was better disclosure. The Federal Corrupt Practices Act was passed. That act primarily strictly dealt with federal general elections, but it eliminated some practices that were believed to be corrupt and again provided more disclosure. The Hatch Act was enacted. That's the act that, and I may get these two confused, there's Taft-Hartley and Hatch. Hatch, I think, is the one that prohibits federal workers from, and I'll know by the year, yes, 1939, the WPA is in full swing, the Works Progress Administration, tons of federal workers doing stuff, and they were accused of helping the Democrats win elections on federal government time. And so the Hatch Act prohibits federal workers from doing anything political on federal time or on federal property, and a few other things besides that. And then the Taft-Hartley Act, that was the act that further prohibited unions, corporations, and also unions from making spending in campaigns, including independent spending, not tied to or in conjunction with a candidate. So now we're up to the 70s and Nixon and Watergate. And boy, there was a lot of money floating around during that time. If you Google Nixon slush fund or Watergate, you can read all about it. Some of you remember it. I remember it in general terms, and I've read about it since. But it was another huge scandal. There were literally bags of money floating around. And next slide, please. So, as was mentioned a little bit earlier, 1971, the Federal Election Campaign Act, the FECA, that was of 1971. Again, we have a money scandal in politics, and it triggers a big law. And this is the first time now that all of these federal laws relating to campaign finance are integrated in one body of law. That's this Federal Election Campaign Act. That's still the basis for a lot of what we do in campaign finance these days. 1974, the law was strengthened. This is the 1974 amendments. The Federal Election Commission is created. That's the first time there's an actual agency to enforce all these laws. Even in Minnesota today, we have lots of laws with no agencies to enforce them, and I'll give you two good examples. One is campaign finance law at the local level. My board handles state elections, not federal. We've got the FEC. But at the local level, the Secretary of State publishes a booklet, but they're not actually charged in statute with helping people. The Office of Administrative Hearings will hear a complaint if you file a complaint, but they're an adjudicative body, so they don't really help people or answer questions either. So there's a body of law in Minnesota with no agency to really administer and enforce it. The only way it gets enforced is if somebody files a complaint. The general laws about what's fair and unfair in campaign finance is similar. So the Federal Election Commission is created, and also in 1974, the Minnesota Ethical Practices Board is created. Now, back then, because remember we're coming right off of Nixon and Watergate and tons of cash flowing all over, back then this was all considered a matter of ethics, and in fact, probably votes were being bought and sold, at least at the federal level, so it really was a matter of ethics. And so the state creates an agency called the Ethical Practices Board and passes a law called the Ethical Practices Act. That board is now called the Campaign Finance and Public Disclosure Board, and the act is called the Campaign Finance and Public Disclosure Act, but generally it's the same with amendments that have happened over the years. What's happened is now everybody realizes that these things are no longer really a matter of ethics in the sense that we think of right and wrong and moral responsibility. They're really a matter of following well understood written regulations and rules about how money works in campaign finance. By the way, in the 42 years of, I think I mentioned the 42 years of campaign finance regulation, I'm the 5th executive director. We also have a staff of 8.6, one person being part-time, and that's the permanent staff. We happen to have 2 lawyers on staff plus myself, although none of the lawyers are the board's lawyer. The Attorney General's office is the board's lawyer. 1976, okay, here comes some big issues. The earlier slide said Buckley versus Vallejo. Buckley versus Vallejo, if you know much about campaign finance law, you've no doubt heard the name. It's the name of a Supreme Court case. It is the preeminent campaign finance law case still in the United States. It provides a lot of controlling precedent. It created some clarity. It created some confusion, like a lot of Supreme Court cases do. But it did set forth a few things that are sort of gospel, and I'm going to deviate from our history line now to talk a little bit more about Buckley versus Vallejo, because it's the starting point for figuring out why we're here where we are today with campaign finance, disclosure, and regulation. So Buckley said, all of this relates to the First Amendment. It's all about freedom of speech, because the most important speech in our government is political speech. Speech about getting elected or helping somebody else get elected or defeated, for that matter. And so this is highly protected speech. So Buckley, as I already mentioned, said that really any regulation of campaign speech is a burden on the First Amendment right to freedom of speech. And Buckley also said that these burdens are not absolute. It takes an important governmental interest to overcome that burden, however, so you have to sort of balance. And what are the governmental interests that are most typically going to support a regulation of campaign speech? And when I say regulation, I mean either a limit or a disclosure requirement. And the 2 most common interests that we look to support campaign finance regulation are what's called an anti-corruption interest, and that means that by limiting the amount of money, for example, that one person or one political committee can give to a candidate, we limit the possibility that that person might be giving money to a candidate in a way that would corrupt that candidate, to cause that candidate to vote, for example, in a particular way. Another important state interest, and I think one that is really important to the Campaign Finance Board, is the public interest in informing voters. Buckley said that it is a valid and important governmental interest to allow voters to know who it is that's trying to influence their votes. So that is part of disclosure. Now, the anti-corruption supports limits on money, and disclosure supports that to some extent. The public interest is really supported by the disclosure piece. You have a right to know who's paying for these pieces of mail that you're getting in your mailbox and where the money's coming from, so that you can better evaluate whether you want to follow that piece of literature or not. So we've got a balancing act. On the one hand, disclosure, and on the other hand, freedom of speech. Now, this is one kind of balancing act. Actually, campaign finance, because we have something on each side, is more like this balancing act. And you might actually picture the First Amendment as being on the left side because it takes a lot to overcome the importance of the First Amendment in trying to regulate campaign speech or money. This is a different view, and I think I like this view in particular myself because the weights on the two sides of the balance are fairly equal. You know, is disclosure more important or the ability to associate with other people in an anonymous way more important? And what is this person in the middle? Well, this person in the middle is tipping the balance. And I think if you think about it, you'll realize that anytime you're looking at competing interests, disclosure versus free speech, and the argument being, of course, that if I have to disclose, well, people aren't going to want to give me money, and therefore I won't be able to speak. So disclosure is an indirect way of suppressing speech, is the argument. The person in the middle, I think, is the Supreme Court, because there is no mathematical formula that can help you figure this out. So we have court precedent, and depending on who's on the court at a particular time, the precedent may go one way or the other. So this balancing act that we see in campaign finance is really, I think, weighed upon in significant ways by the Supreme Court and its decisions. As I mentioned, for about 100 years, corporations were prohibited from making independent expenditures, and now they can make them freely. So that really reflects a change in the court, I think, more than a change of any other type. So back to the Buckley problems, and I put problems in quotes because it's not a problem for everybody. It's mainly a problem for people who want more regulation and disclosure. Start with money equals speech, so that means if you regulate money, you regulate speech. A couple of other things, though, that we have to think about, and if you've been getting things in the mail about the election that's happening tomorrow, you might want to think about these things. Not all the things you get in the mail may have somebody's name and address on them as to who put them out. I haven't seen them, so I don't know, but they may not all have that. First of all, Buckley says you can only regulate speech that is for the purpose of influencing an election. That sounds simple enough on its face, but when it comes right down to looking at various communications, the question is, how do you tell when a communication is for the purpose of influencing an election and when it might have that effect, but is really for some other purpose? As soon as you start talking about purpose, you're talking about making evaluations that human beings make. And this is really important for advocacy groups because they mostly don't try to influence elections, so most of their speech is not for that purpose. But once in a while, they might want to do something that is for the purpose of influencing elections. On the other hand, they don't want their ordinary everyday speech to get caught up in a finance regulatory system. Now, this isn't any problem for a candidate committee or a party or any group that exists really only to influence elections, because the Buckley court said if you're a candidate or a party, everything you do is to influence an election. So you're going to report on everything. So it really is only an issue for us, the Campaign Finance Board, as regulators, and for legislators and citizens when we're talking about what we call non-major purpose associations. These interest groups that have a major purpose, but it's not elections, but sometimes they wade into the election situation. Well, Buckley thought that they were going to give us a nice, easy way to solve the problem of figuring out when something is for the purpose of influencing an election. They didn't really put it out there very well because they put it in a little tiny footnote. But the Buckley court said that when we're looking at these interest groups and their speech, which we have to be really careful of, we will know if it's for the purpose of influencing an election if they use 8 words that have come to be known as the magic words. And the court did say, or similar words. But those 8 words are essentially vote for, vote against, elect, defeat, support, oppose, things like that. So if a communication uses those words, we know it's for the purpose of influencing the election. Couldn't hardly be anything else, right? So that the result is magic words, that's express advocacy. It's going to be subject to disclosure no matter who says it. No magic words, no disclosure, unless, of course, you're a candidate committee or a party unit where you disclose everything. But if you're somebody else, you can say an awful lot, and if you leave out those words, you're not in our system. And I'm going to have some examples of those. So we left off with Buckley versus Vallejo, and there were a couple of developments. The first one, you might guess, people started avoiding the magic words. Nobody used them anymore. And so there was no express advocacy. And this is in 2002, the Bicameral Campaign Reform Act, BCRA, was enacted. That was an update of the Federal Election Campaign Act, and that sought to address these new things, namely avoidance of the use of these magic words. And it introduced the concept that we know of as functional equivalence. And that got fleshed out then in a couple of cases, and I'm going to move just forward a little bit. There were some other disclosure provisions developed, and I'm going to talk about two of them in the next minute or so. One of them was the concept of the functional equivalent of express advocacy. So you've got express advocacy, vote for, vote against, etc. What about these ads that say everything right up to, but excluding vote for? Well, the court and the legislature recognized that, these were really not for any other purpose but influencing an election. And so the legislature passed and the court upheld, the lower court upheld a functional equivalence test, which said essentially that if you look at a communication and no reasonable person could conclude that it's anything else for any other purpose than to influence an election, it's the same thing as express advocacy, and it's subject to the same disclosure. That was challenged in two cases, McConnell, which is Mitch McConnell, and Wisconsin Right to Life was the second case. And through those two cases, Justice Roberts fleshed out and created this concept of the functional equivalent. The argument in those cases was Buckley said, and this is, by the way, this is interest groups now, not candidate committees. So some interest group out there runs an ad. They say, Buckley said, if we don't say vote for, we're not in the system. It's not subject to disclosure. The legislature said, if it's the same thing, you're going to be in the same system and subject to disclosure. So the lawsuit claims that the Congress went too far. Congress went beyond what Buckley could say. Buckley said you have to use those words. Well, the Supreme Court, and Buckley was the Supreme Court, the Supreme Court says no, Buckley wasn't really that narrow. You don't have to use the magic words. If it's the functional equivalent, it's just as good. By the way, at that same time, people were starting to move one step further away. If you use magic words or their equivalent, you're going to be in the system. What do you do next? Well, you try to think of something that maybe has some other interpretation than to influence an election. How about an ad that talks about a policy issue and then tells the listener what the official's policy position is and tells the listener to call that official? There you go, something that has a purpose other than influencing an election. That's called electioneering communications these days. And the BCRA, Bicameral Reform Act, also covered electioneering communications. And that was touched on in McConnell and Wisconsin Right to Life, but really finally finished up in Citizens United in 2010, where the court said, and here's what an electioneering communication is. Now it has a definition. It doesn't have to talk about elections or anything. If you mention a candidate, clearly identified candidate, 30 days before the primary or 60 days before the general election, and you distribute that communication, and there's definitions of how broadly it has to be distributed. If you do that, you're subject to the disclosure systems. It doesn't really matter what you say because everybody was using that method to avoid disclosure. And Citizens United clarified that disclosure is okay in that situation. So now, there's a little bar in the blue line between 2007 and 10, which I'm going to read for you because it's quite small, but this is when the federal Congress passed electioneering communications and functional equivalent language. So they fixed those loopholes that had been created by interpretations of Buckley. Minnesota didn't do that. And so at this point now, Minnesota in 2010 falls behind the federal system in where it requires disclosure. And that has a significant effect, and it's still the case today. And that's what I just said. A couple of other cases have come up even since Citizens United. 2010 seems pretty recent, and that was a big case. But another one came down in 2014. It was called McCutcheon versus FEC. McCutcheon wanted to give money to a whole lot of candidates, and he wanted to give each of them the maximum that he could give to one candidate. Well, at the federal level, there was another law that said a donor can only give so much in total, no matter how many candidates. Once you hit your total, you got to stop. And McCutcheon said, well, that makes no sense, because if the reason for a limit is corruption or undue influence, you know, if I can give the amount to the first 12 people, why can't I give it to number 13 or 14? They're not even the same people, so how could I be corrupting them? Ultimately, the Supreme Court agreed with that analysis, and they struck down the federal law. Minnesota had a law that I thought was different enough to survive. In Minnesota, we didn't have an aggregate donor limit, but we had a limit on how much a candidate could accept from big donors. If a person gave more than half of the limit, you add those people up, and there was a limit on how much the candidate could take from that group of people. And in Seaton versus Weiner, Deanna Weiner was the chair of the Campaign Finance Board. Mr. Seaton was a donor. That law was challenged, and at the federal district court level in St. Paul, we lost at the initial step, and the Campaign Finance Board was enjoined from enforcing that law in the 2014 election. And then in 2015, the legislature, at the board's recommendation, fixed that by reluctantly removing that limit, because the court's opinion was quite strong that he believed it was unconstitutional, and that if we went all the way through a trial, we were going to lose. And so the legislature fixed that, and so that limit no longer exists in Minnesota. 2013 through 2015, the Campaign Finance Board makes 3 recommendations to the legislature every year. And by the way, they've made them now for 2016 as well. Actually, it's a carry forward from 2015. Number 1, provide for disclosure and regulation of the functional equivalent of express advocacy, so get rid of that loophole. Number 2, provide for disclosure of electioneering communications, those candidate communications just before the elections. And number 3, when nonprofits are permitted to use their money, improve the disclosure about where they get that money. This is the dark money picture that you see at the federal level. A nonprofit gets money from who knows where and then donates it on. The donor is the nonprofit, and nobody knows where the money really came from. And Minnesota has that same problem. The board has done a couple of things to clarify independent expenditures. I will take calls, or people can talk to me offline. I'm not going to go into those things. What's the future hold? Well, it's almost anybody's guess. Constitutional amendment, maybe statutory changes at the state level. There are at least 3 or 4 things that the state legislature could do to improve disclosure that so far it's declined to do. There might be more litigation. There are a couple of Minnesota statutes that might even be subject to further challenge. I want to give you some examples, and I'm going to go through them quickly. And by the way, anybody who would like a copy of these slides, you can email me. It's gary.goldsmith@state.mn.us, and I'll be happy to send you a copy of the PowerPoint which has this information. So that's gary.goldsmith@state.mn.us. So what's disclosed? Well, we sort of covered this. Money spent by candidates, independent expenditures, vote for, vote against, etc., are the 2 things that are disclosed. But here's some interesting information. 2010, just looking at the House, candidate expenditures, 4.8 million, independent, 3.2 million, for a total of about 8. 2014, only 4 years later, candidate expenditures, 7 million, independent expenditures, 10 million, and total of 17 million. Now, remember, this is after Citizens United. And Citizens United, the main point, it upheld electioneering communications, but the main point of Citizens United was corporations, both for-profit and nonprofit, can use corporate money to make independent expenditures. And the court concluded that independent expenditures could not possibly corrupt a candidate because they're independent. So the anti-corruption state interest didn't exist according to the court. Now, most people that I talk to in the real world don't believe that because everybody knows who's making the independent expenditures and they have the same effect as if you'd given the money directly to the candidate. I'm not going to talk about this slide except to say that independent expenditures are 48% of all of the spending in the 2014 election. So candidates and parties are not quite drowned out, but not too far off. And this graph, again, I will send you if you ask me for it. But what it shows you, particularly on the 3 or 4 bars on the right, that sort of purple column, that's your independent expenditures that are not parties and not candidates. So it's grown tremendously since 2010. This is one more that talks about the candidate's voice in the election, and I'll just give you the numbers. I'll take the one on the right, Lori Halverson versus Jennifer Wilson in District 51B. Both of these candidates agreed to spending limits. Halverson spends just under $55 million, Wilson $34 million, but independent spending is $81 million for Halverson in support of her, another 120 in opposition, so 200 million there, and 152 million in support of Wilson, and 51 in opposition. So another, I'm sorry, I said 2 million, 200,000. So you've got $400,000 in independent spending and less than 100,000 in candidate spending. So whose voice is being heard now?
I think a lot of Minnesotans probably don't know what Jeff Johnson stands for.
It seems like schools are not Jeff Johnson's priority.
Jeff Johnson cut early childhood spending. That really bothers me.
Any cuts to that would be devastating for our families.
Our kids are our future, so how can you do that?
I would hate to see Minnesota take a step backwards in education.
Students in the state of Minnesota deserve far better than that.
I trust Mark Dayton.
Do you think Governor Dayton is the right choice for moving Minnesota schools forward?
We know.
We know.
Yeah.
I labeled this expressly advocating, and let me say they did not say the word vote for, vote against, none of the 8 magic words. My next slide just has the last about 2.5 seconds of this ad. I'm going to play it and just watch the text. There it is, vote Mark Dayton for about 2 seconds. Now that's the difference in this particular ad between something that would be subject to disclosure and something that wouldn't. Now this ad, it happens, I think the Dayton committee ran it. So being a candidate committee, they disclose everything. But if an independent group ran that, without the last 2 seconds or without the text, they could have run that and not had any disclosure required at all. I think I'm going to skip through these examples because you can't hear them, and that doesn't help you or the audience out in the out in the listener group here. But I will tell you just a little bit more about some of these, and I do have at least one that's a graphic. We already talked about functionally equivalent.
If you like your current insurance, you keep that insurance, period.
Obamacare has been a disaster, and Mark Dayton's MNsure has made it even worse. But Dayton championed MNsure.
I think it's performed phenomenally well.
Sadly, the facts are clear. Missed gold. $150 million spent with terrible results, all while MNsure executives received bonuses.
Phenomenally well.
Mark Dayton's lack of judgment has cost Minnesota too much. So how would Minnesota fare without Mark Dayton as governor?
Phenomenally well.
Okay, so nowhere is the word vote for or vote against used at all, but clearly, given the time it's run, but even without that, it's all about Governor Dayton and the fact that, according to the advertiser, Minnesota would be doing phenomenally well without Mark Dayton as a governor. Now, this particular one has a prepared and paid for notice on the bottom. That's because it was run by a political committee, which is a group whose major purpose is influencing elections, and remember, they disclose everything, so they did have to disclose this. But it could have been run by a corporation, and they wouldn't have had to tell us about it at all. Here's another one. No disclosure required. It's a functional equivalent. State Representative Jennifer Loon took money from liberal donors, legalized gay marriage, increased government spending. Be sure to vote in the primary August 12th, Liberal Representative Jennifer Loon. Even be sure to vote isn't enough to trigger this being express advocacy, so no disclosure required. Here's two. One is required, has disclosure required, and one doesn't. Even if they're run by the same person and they look a lot alike, the one at the bottom says, vote, at the very bottom line, vote Carolyn McElpatrick for Minnesota Representative. And the other one is a thank you to her. It says call her, but it doesn't say vote. So this is one that if Minnesota had electioneering communication statutes would be subject to disclosure, but we don't, so it's not. All right, what next? Well, corporations have a big voice. The public, according to many now, don't have a very big voice. Candidates, according to the statistics that I just showed you, have a shrinking voice. I mean, 1 to 4, actually 1 to 4 spending difference between candidates and independent expenditures. A constitutional convention, some people think so, but if you've done any research, you know that's a problem. Thanks again to the Supreme Court for my free speech is worth more than yours. Well, my point here is that this was an act of the Supreme Court. And I told you before that, I mean, the Supreme Court, as they pointed out themselves from time to time, is really 9 unelected lawyers. And they change, the consistency of the court changes, and as it does, the temperament and the opinions of the court change. Citizens United had to actually outright overrule one case and partially overrule another to say that corporations have the same right to freedom of speech as individuals. You've probably heard this, sunshine is the best disinfectant. That's referring to disclosure. It was actually said back in 1913 by Justice Louis Brandeis, Supreme Court Justice, not in a case, but in an interview. Here are some more important things, I think, that have been said more recently. With the advent of the internet, prompt disclosure of expenditures can provide shareholders and citizens with the information needed to hold corporations and elected officials accountable for their positions and supporters. That's that public interest. Also would have something to do with the anti-corruption interest. Shareholders can determine whether their corporation's political speech advances the corporation's interest in making profits, and citizens can see whether elected officials are in the pocket of these so-called moneyed interests. The First Amendment protects political speech, and disclosure permits citizens and shareholders to react to the speech of corporations in a proper way. This is aimed at corporations, but it really is of general application. So this is talking about disclosure, permitting shareholders and citizens to react to speech. That's the public interest in knowing who's behind the message so you can better evaluate the message. This transparency enables the electorate to make informed decisions and give proper weight to different speakers and messages. How many people know who these quotes are from? You don't have to shout it out. Anybody recognize them? Well, every one of them is from a section of Citizens United, the 2010 case that allowed corporations to make unlimited independent expenditures. And they're the words of Justice Kennedy, the author of the opinion, in justifying essentially the decision, because in this world of internet and so on, the disclosure is going to be there. He also said this: a campaign finance system that pairs corporate independent expenditures with effective disclosure has not existed before today. I would suggest to him that it does not exist even yet today, some 6 years or 5 years after Citizens United, not in Minnesota and not at the federal level as well. So what can you do? Well, if you have an opinion either way, make your voice heard. Your legislators are the ones who make the decisions. And that's how you can affect campaign finance disclosure. And how money is raised and spent in campaign finance in Minnesota. If you don't do that, don't expect results. It won't happen. Thank you.
Thank you. We're going to take a short break, and then we'll come back with questions.
If you see something suspicious, say something to local authorities. Maybe you're commuting to work, going to school, or out running errands. We all play a role in keeping our community safe. Report suspicious activity.
So we're going to start the second part of our program tonight with some comments from two elected officials from our local area. One is Representative Jerry Newton, who's currently in the House of Representatives from Minnesota, and the other is former Representative Kathy Tingelstad, who had served our area in the past. And so they're both going to have some reflections on what Gary said, and then we'll have questions from the audience that came up to me in the form of cards. So Jerry, do you want to go first?
Yeah, thank you, George, and thank you, Gary, for coming out. I really appreciate making the trip out here. You know, one of the things that we worry about is how much money and the dark money that's in politics, but I think we also have to put that in perspective just by looking at the current race. The amount of money, for example, that Jeb Bush has acquired and where he is in the polls. And in other cases, you know, where a lot of money was thrown into campaigns and the candidates who had that money behind them lost. So it also has to do with not just how much money is put into a campaign, but how effective that money is and who the candidate is. One of the most difficult things for me is when we have literature that comes out against us that we have no control over, and it says things about us that simply aren't true. It's hard to fight. I'll just make mention of a case. In 1988, I ran against Jim Abler, and it was the first time both of us ran. There were 22 pieces of literature in support of me and 26 pieces of literature in support of Jim that neither of us had any control over. I actually had to call him and apologize for some of the literature, things like saying Jim Abler, who's very health conscious, was making kids smoke. You know, it was just inconsistent, but, you know, there's not much else you can do about it other than apologize. And then I asked the Democratic Party to contact whoever it was that was doing this and ask them to stop sending the literature on my behalf. So, you know, this is, having campaign support from outside groups is a double-edged sword. Sometimes it works, oftentimes it doesn't. And I think people are so inundated with all of the literature, the things we put out ourselves, and the other literature that comes to your house, that people basically ignore it. So, turn it over to Kathy.
Thank you. And Gary, I really appreciate that, the history that you gave, because it was really good to put into context of where we've come and where we're going. And I think it was very enlightening, especially when we looked at the charts there of the difference between the amount of money that candidates spend versus the independent expenditures. And like Representative Newton was saying, you know, as a candidate, you don't have any real knowledge or action over those brochures that come out from these independent expenditures. Yet the way the electorate looks at it is, you know, it's either for or against a certain candidate, and they, I would think, almost assume that the candidate knows about it and, you know, is representative of their campaign. And I have to say that the last time I ran for the legislature was in 2006. And so things have gotten a lot nastier, so to speak, since that time. I mean, it used to be that, you know, a candidate could fairly easily raise funds with the funding that we had with the rebate program and run a clean campaign based on issues. And there was very little independent expenditure back then. But I think what has really changed is that there's so much at stake at the legislature. I mean, when you're looking at, what was this last one here, $42 billion two-year budget for the state, that's a lot of money. That's a lot of organizations that are getting funded through the state of Minnesota. So they have a lot at stake in making sure that their opinions are heard at the Capitol and that they have influence over those decisions. And so when there's so much at stake, and especially in the House of Representatives where the majority party switches, from Democrat to Republican every few years or so, and that's been happening a lot over the last decade or so, when an outside group can influence an individual campaign with, 10,000, 20,000 or more, with their spending, they can really influence which party is going to have the majority in the House of Representatives. And for that, that means a lot of other things about who's getting the funding. So when there is so much at stake, these outside groups, see a definite benefit with funding those campaigns for or against. But we were talking right before we got up here that just how difficult it is to find new candidates these days, because when there are so many negative campaign pieces out there in a typical legislative race, you really have to be a candidate with a strong backbone to be able to go against, the information that's being put out there, and you have no control over it. And, I applaud Representative Newton for calling his party and saying, please stop this, please, tell these outside groups, not to do it, because as a candidate, you don't have that control. So I really see a shift in how things are moving. And as we looked at those bar charts, it looks like that's even perhaps more of a bigger trend as we go forward. And certainly, again, in the 2016 elections, what's at stake is the majority in the House and possibly even the Senate. And so when you look at the funding of those campaigns, some of those organizations, for them, it's a small amount of money to put towards a race that can make a huge difference in which political party takes the majority in the House or Senate.
And if I can just add one thing, I think on Gary's chart, it showed the $7 million or so that was spent in the legislative races. But if you subtract out the top 15 races, it probably comes down to 22 to 25,000 per candidate running for the House. So it's much less for the overwhelming majority of candidates who are running. And I just think of the last election, the most egregious campaign, I think, was the one in St. Cloud, where close to $1 million was spent by both parties and by outside groups on the campaign. And I can't remember, Representative Knobloch won by 50 or 60 votes. 66, I think a very close election. And Kathy also touched on something that I'm really not very happy with, and that was in the last session, there was a $10 million shortage that had to be found in both the House and the Senate. And I won't go into the details, but they had to look for the money. And what happened was they ended up eliminating the PCR, the campaign finance refund, the $50 refund that people could get. And for me, it looked like a protection issue for both the leadership in the House and the leadership in the Senate, Republicans and Democrats, that it helps those of us who are in office, because we had a chance up until, I think it was July, wasn't it, to raise money on the PCR form. But whoever decides to run against me between now and probably the caucus time won't have that advantage. And so it helps incumbents in both the House and the Senate. And the House wanted to keep the majority of Republicans, the Senate wanted to keep the majority of Democrats, and so it was sort of this collusion and an agreement that really hurts candidates who want to run. And it's one of the reasons that we're going to have trouble finding candidates to run. In Rochester, Kim Norton's seat, it was a swing district, and there have been 10 Republicans who have been approached to run, and nobody wants to run for that seat because of all the problems of trying to raise money and all of the other issues that go with running an election.
I might comment on the public subsidy refund program. That's a program that's fairly unique to the state of Minnesota, and under that program, a donor can give $50 to a candidate who's agreed to limit spending in their election, so they have to agree to the spending limit. Excuse me, and that donor will then get the $50 refunded by the state from the general fund of the state. So it is a state expense. The Campaign Finance Board, coming into the 2016 legislative session, made only one recommendation, and that was that the legislature find money to refund the contribution refund program. It does cost about $10 or $11 million every 2 years, but there was a big budget surplus carried forward into the new biennium, plus I believe the projections showed that there's going to be an even bigger surplus. The board thinks that this program is important because it thinks that getting individual voters, especially voters who can't afford otherwise to donate, involved is important. There have been research studies that have shown that even giving a small amount that you get back to a candidate helps a voter solidify their relationship with that candidate. It makes them more likely to vote and makes them more likely to stay on top of the issues. So they become an educated voter. And so for those reasons, the Campaign Finance Board has recommended the legislature try to find money for that program.
Thank you. A lot of the questions that we got from the audience reflect things that we've talked about here today. In the subsequent part here, the one question is directly for Mr. Goldsmith. Who won the election that had the high independent expenditures that you showed?
Sure. In the one that I showed in the right-hand column was Lori Halverson, who was the incumbent, against Ms. Wilson, who was the challenger. Halverson spent $55,000, the challenger $34,000, but independent expenditures for Halverson and against the challenger were $176,000, so $231,000 on that side. On the Republican side, the independent expenditures were higher, $203,000, so $237,000 on that side, and the incumbent prevailed in the election, so Halverson won. But more than $230,000 in spending on each side.
Wow. Yeah, that was one when you showed that slide, there was a gasp from the audience. So.
and as Representative Newton says, that wasn't the most expensive election.
Right.
So I got some technical questions here. We'll start with those. If a donation is made at a website in 2015, but it doesn't get credited until 2016, which year does that count as?
For the donor or the recipient? It counts for the recipient at the time the money is available to be removed from the website account, regardless of whether the recipient actually removes that or not. Some web processing sites have a short hold period. So if it's made on December 31st, the candidate may not be able to transfer it until January. In that case, it would be a 2016 contribution from the candidate's standpoint.
Okay. Next one, how do candidates loan money to their own candidacies? Isn't that simply a self-financed campaign? What happens if a candidate can't raise enough to repay it?
It's a very good question. First of all, if a candidate doesn't sign a public subsidy agreement, take, for example, Governor Dayton in his first term. He didn't sign the agreement, and he had basically a self-financed campaign, because unless you agree to that limit on self-financing, Buckley versus Vallejo says the state can't limit you. So now we look at just those candidates who have agreed to the spending limit. They also are agreeing that they will not lend their committee more than $5,000 in the 2-year period. And if they can't, and so they can lend themselves the same amount as they could give themselves, and the combination of lending and giving can't exceed $5,000. So if they lend themselves money and can't pay it back, it becomes a contribution, but it's still within the limit. So if you sign the public subsidy agreement, you really can't self-finance.
Okay. If an elected official had money left over from their own campaign, can they give that money in the next election cycle to other candidates? Or do they have to close the account? Can they reopen the account for their reelection next cycle?
The statute generally prohibits candidates giving their money to other candidates unless they really are going to terminate their committee and not run again. So if you decide to give money to another candidate, you have 12 months from that date to end your committee. Now, if a candidate terminated a committee, gave money, and then opened a committee shortly thereafter for the same office, I would be concerned that the Campaign Finance Board might look at the substance of that transaction rather than just the technicalities, and conclude that that candidate was in violation of making contributions to other candidates.
The next series of questions relate to law changes. Are there any changes in the law that can possibly get passed in the next session? You had mentioned some changes, Gary, that would potentially be up for next session?
Well, the board hopes, of course, that they'll refund the contribution refund program, but because this is not a general budget year and because the Department of Revenue is involved in processing those refunds, I personally don't hold out a lot of hope for action on that particular matter. I can't predict what might happen. Both members in both the majority and minority in the House, so both Democrats and Republicans, have told me that they want to have conversations with me about moving something forward in campaign finance. To date, nobody's scheduled anything, so I know that they're thinking about it. I don't know what they're thinking, and I don't know whether they'll try to move anything this year.
At the national level, can Congress do anything to reverse Citizens United?
Congress really can't, in my opinion, do anything to reverse Citizens United because it's a Supreme Court decision based on constitutional law. They didn't just strike down a statute that Congress passed so that Congress could fix the statute. They just went all the way and said that corporations have the same First Amendment rights as individual human beings, and that's under the Constitution. So, at least in my opinion, and I'm a student of constitutional law as related to campaign finance, I don't think there's anything significant that Congress can do. People both at the federal level and the state level look at things like shareholder approval, where the laws of your corporation, your incorporation statutes would require shareholder approval for certain types of corporate expenditures. Things like that, I don't know whether they would pass muster under the First Amendment, but those are ways that might be tweaked around the edges.
A related question then, California is making efforts to limit Citizens United. What can a state actually do to counteract the court decision?
Well, again, my opinion is very little. Again, at least Minnesota corporations are incorporated under Minnesota law. There has been legislation looked at. I don't think it ever seriously moved in either body, but there's been legislation looked at and I think introduced that would have required shareholder approval before corporations could engage in political spending. The problem for us is that the corporations are mostly not Minnesota corporations that are doing this. The interest groups are national. So again, I don't think there's very much that a state legislature can do except disclosure.
Are you aware of the Anti-Corruption Act the cities have enacted? Any city anti-corruption acts? The example is Tallahassee, Florida.
Somebody sent me something a while back about anti-corruption at the local level that was quite comprehensive, but because that's so far from the jurisdiction of the board, I'm not really following it.
Anybody? No? I haven't heard of it. Another related question, is there any way to get more disclosure required at the local level? And so even within our county or our city, could we require things by ordinance here?
The Chapter 211A of Minnesota statutes is the local campaign finance statute, and I believe that statute actually includes a provision that says that unless otherwise provided by law, local authorities cannot enact more stringent laws. Now, Hennepin County and Ramsey County have their own laws by statutory authority, but local officials really don't have that ability. But the legislature, of course, does, and that's an area of law that could use a good looking at.
Thanks. Do you have anyone have any examples of successful ways to make corporate expenditures public?
There are pretty good ways, and I mean they've been passed at the federal level. They've been challenged in McConnell versus FEC in Wisconsin, Right to Life. That's the functional equivalent of express advocacy. And in Citizens United, which is the electioneering communications. So that, first of all, that's what you need to do to bring the type of communication in, because they're not really running vote for and vote against ads. They're running ads that escape disclosure. So first of all, you have to expand disclosure within constitutional limits that have been firmly established and clarified by the Supreme Court. Once you do that, the disclosure system is mostly in place, with one exception that the board has recommended in 3 past years, and that is this issue of so-called dark money, and that's a term that people use. I don't know if everybody understands it, but the concept is that a nonprofit corporation that raises money from lots and lots of donors, or maybe only 1 or 2 donors, we have no idea, then it is the donor to another group that reports to an agency like the board. So we see the intermediary donor as the source of the money, when really the source is that nonprofit corporation's donors. Now, we have a statute in place to get at that original source, at least one level up, but it's very weak because it was a compromise in 2010 when Citizens United was passed, and so compromises are often weaker than we'd like. So the Supreme Court has established that you can do it. It just needs to be done.
If I can add also, through the internet, we have individuals and groups that dig into where money comes from, campaign money comes from. And they expose it every once in a while, but there doesn't seem to be any public outcry. People seem to figure out, well, that's, it's the Koch brothers or whatever it is. They just seem to realize that there are big donors, whether it's a union or whether it's a corporation that's doing that.
That's a really good point. I don't take a position typically on disclosure unless the Campaign Finance Board takes a position. But one of the questions that I raise with the board and with others is, to think about how important is some of this. 2 of the organizations that have been opposed to better disclosure at the state level are Minnesota Citizens Concern for Life and the NRA. But we know what those groups stand for. We know what their principles are. They are sort of one-issue type groups, and everybody knows what their issue is. The argument that they make, and I think there's some merit to the argument, is, does it really matter who their 70,000 or 100,000 donors are, or even who their 10 biggest donors are, when we already know who they are and what they stand for? Are we voting the way they want us to because we agree with their principles, and does it have anything to do with who donates? Now, on the other hand, there are groups like, and I'll probably get the name wrong, but Americans for Prosperity Minnesota, which is a branch of a national group that we know almost nothing about except that it seems to exist only to influence elections. I think there's a stronger case for disclosure of their sources of money than there is for a lot of these other organizations.
Some of these questions sound somewhat sad and desperate, and reflect the feeling of hand-wringing that I think we've been having as we listen to all this. Because it really does seem like there's quite a loss of democracy, a loss of the ability of candidates to have their voices heard, and a loss of people. So one question here. How can one voice overcome the effect of the voice of a pack with all the dollars behind it?
I would say just having a strong candidate. That, as I mentioned before, the amount of money that went into the Jeb Bush campaign, $100 million, really hasn't helped all that much. And it's probably because of his personal candidacy more than anything. Not anything to do with his character, but he just, from my point of view, seems to lack interest in the campaign. So if you have a strong candidate and has good issues that resonate with the area that they plan to represent, I think that's a way of overcoming it. And for many of us in the legislature, there are roughly 15 races in the House and 7 to 10 in the Senate that matter. The rest of us don't matter. And so what we're looking at is to hope to get under the radar, to not be one of the targeted races. And so that you and your opponent can run their own campaign with their own literature. And as a Democrat, I'm going to have a piece of literature from Education Minnesota. My opponent, whoever that may be, will have a piece of literature from the Chamber of Commerce. That's kind of the way it goes. But the best thing to do is to, if you're going to win an election, win by 56 or 57%, and then you're probably not going to have money coming against you the next election.
Yeah, if I could add to that as well, I remember when I was in the legislature, we would always say, be careful what you say on the House floor or how you treat other people, because you don't want a target on your back. You don't want the other party to say, let's get them in the next election. So, I'll say that that's dangerous to some extent, because I'm wondering if it's changing some of the votes of legislators who would say, well, I would maybe vote this way, but that'll put a target on my back, so I'm going to vote the other way. And that's really sad. I mean, hopefully that's, a very small percentage of the votes. But it is the truth that, you look at the repercussions of your vote and think about how it is going to affect the next election, and often we hear, well, a certain controversial issue at the Capitol, that's going to be on the next election ballot, or somebody's already writing the brochure, for or against that legislator, based on information that happens in the House and Senate. So it's kind of sad to some extent that you have to look that far down the road, but it's reality of politics, I would say, as well.
I would add to that, I think it's very much a reality when you're talking about campaign finance disclosure bills, because those bills are routinely scored by the opposition groups. And when a bill is scored, that means they're keeping a scorecard. They'll publish who voted with them on all of the multitude of issues that they score. And if you're 100%, then you're going to get their members' votes. And if you're lower than that, you might not, or you might even get a lit piece against you. So campaign finance disclosure laws have had that problem, that interest groups that don't like them score them, and that does very definitely influences people's votes, particularly if it seems like the bill may not pass anyway. It probably won't even come up for a vote, because unless it's going to pass, there's no reason to bring up a bill and make people vote on it.
A related question to some things that Kathy had said. Can you give us hope that a good person would be willing to run for office in the current political climate?
Well, I would hope that all the candidates are good people, but it's a matter of how thick is your skin. What are you able to put up? And we were talking earlier, even with legislators who have children that are school age while you're in the legislature, and I certainly had that when I started. My sons were in kindergarten and second grade, and so they were getting to be college age by the time I retired from the legislature. But part of the reason I did retire was because they were getting bullied at school related to how I was voting on issues. And, certainly that's the reality of a political family. But on the other hand, if somebody has an issue with my vote, please deal with me directly. Don't take it out on my kids. And so that is the reality of, what people are looking at when they decide to run for office. And, Representative Newton referenced the Kim Norton race down in Rochester, and the people that they're interviewing to potentially run for this seat, 10 Republicans have said no. And part of the reason is because how it would affect their family, how it would affect their business, if they run a car dealership or something, and so they're known then as a Republican, does that mean every Democrat in town will not go to their car dealership? I mean, those are the political realities, and it is really sad, but it should be to the point where people who are in elected office should be the best and brightest in our state. And, sadly, because of the realities of what it takes in politics, I don't think that's the case all the time.
I just have to second that, and I think of the vote that Kathy had to take on the gas tax, and she was one of the Republican 6 that voted for it and were severely punished for it. And as a regular feature of my caucus, the Democratic caucus, when there's a vote that comes up that has to do with abortion, some people are given the option of not having to vote, or to vote something other than what they probably would do, because they know that in the district that they represent, to vote one way or the other would affect their candidacy. So, it's not a game for
the weak at heart.
The weak of heart. That's right.
I think we have time for one more question, and the one I want to end with: is there a way that we can stop the dollars coming in from outside the state that influence the state elections?
No.
Well, I wanted to thank you guys for your time tonight. We do have a thank you gift for you that I'll give you afterwards. I wanted to thank you for coming all the way out here on a snowy night, and thanks to everybody in the audience. Thanks for QCTV, and good night.